My name is Morse Mirabon, and I'm an attorney here in Los Angeles, California. The majority of our caseload involves cases pertaining to the violation of the Americans with Disabilities Act.
With these wheelchair cases, when we first started to see them in the courthouse, it wasn't obvious that somebody had invented a new way of doing business. It took a while to realize that, and then we started seeing the same names of lawyers over and over again, and the same names of plaintiffs. And I think by now every judge has had 5 or 10 of these cases.
If you really need access to justice, you get behind the throngs of ADA lawsuits that are clogging the courts right now.
There are people out there that, due to their poverty and sometimes greed, are using lawsuits as a form of regular income, and I think that's wrong. It really pisses me off because that puts a dark light on the problems that I have and the legitimate lawsuits that people do file.
What could we have possibly done wrong? We have our stamp plans. Within our stamped plans, there are 12 pages that are signed off and stamped by the LA County Disabled Access Division. You need to go through every single department within the city, and I thought, who could have failed along the way? I mean, these are so-called experts, and they wouldn't have let us open if we were not completely compliant.
There is no provision which requires the government to enforce the codes. That's why she was not told by the government exactly what she needed to do to comply. If she had taken it upon herself to determine what the law is, she would have found out what the law requires regarding the Americans with Disabilities Act. The ignorance of the law is no excuse.
The California regulations are about 500 pages, covering all manner of things that are required of hotels, of restaurants.
I think by and large business owners do the best they can with the information that's available to them. Of course, the laws can be so complicated that as a practical matter, it's impossible for people to be aware of everything.
We were opening a business, so we were consumed with everything from marketing, PR, our menu development. Who are our customers going to be? How do we reach all the local businesses? You know, Michael kept saying, I'm a cook. You know, and I kept saying, I'm like a marketing PR person.
I would have to become an architect and a builder and an engineer and everything else in order to understand the majority of it. When I was hit with the lawsuit, it wanted probably some $500,000 or $600,000 worth of work done. Put an elevator in. It was truly overwhelming. You know, at that time, I was basically told, we'll let you out for $18,000.
The lawsuits are filed to settle them. They've never been about taking a case to trial, and frankly, most people can't afford to take a case to trial, so they're going to settle, and that's how they make their money. They don't make their money on trials.
The first thing that a business should do when they get served with a lawsuit is try to minimize the cost of the litigation, treating the case as World War III, hiring an attorney. All it does is escalate the costs and so on. We're asking for $4,000, okay? This is not a Supreme Court case. There's no need to become personally offended.
I think all of these cases are defensible, but the economics of them makes it impossible. That's why attorneys sensibly advise their clients to settle the case, and that's why the clients pay up.
Unfortunately, Kathy Reese McNeil hired a lawyer who was inexperienced with ADA litigation, and they chose to fight the case all the way to trial. Ultimately, Kathy won the case, but she still paid a devastatingly high price for her victory.
It cost a lot. It hurt financially. It was $140,000, just shy of $140,000. I had to borrow. All my savings were gone. I was pretty much wiped out financially.
These are not great burdens to the business community, so I don't think it's going to eat into their bottom line, so to speak. To my knowledge, I'm not aware of a single business that has gone under because of a disability access lawsuit.
We received a lot of calls from a number of merchants in Julian, California, which is where we are right now. About 67 small businesses received demand letters from an attorney who indicated that he had come up for the weekend and had difficulty getting into places.
Physically challenged San Diego attorney Theodore Pinnock is demanding between $2,500 to $5,500 per business for alleged ADA violations.
Since this attorney was seeking in excess of $200,000 from the 67 businesses, there was some level of hysteria and panic in the community, and many of the businesses closed after they got the letters. If you look over here, this business with the words Tucker's Treasures on it used to be Julian Bell Book and Candle. Across the way, if you look upstairs, that's where the Julian Gallery was. That business closed immediately after the letters were sent. Over there where you see Mustang Sally, that business closed. The restaurant just to the left of it also closed shortly after that. There was another small shop called Enrichments that closed not long after that.
After collecting settlement money from those businesses that did not close, Theodore Pinnock never returned to Julian to check up on any accessibility changes being made. Instead, he continued his string of more than 2,000 ADA lawsuits against other small businesses throughout the San Diego area.
Okay, I'm George Coles, and I'm president of Coles Fine Flooring. We have 7 stores, 130 employees. We've been established in San Diego since 1947. I was sued by an attorney named Ted Pinnock. In the suit, Mr. Pinnock says that he was in the store on 2 specific dates. Now, I have 10 digital cameras in that store. We searched through those archives very carefully. We looked 7 days before the 2 dates and 7 days afterwards. We could not find Ted Pinnock in my store on those recordings. When we confronted him, he then filed a second lawsuit on me. He used a plaintiff with a fake name. We could not find her. In fact, we had an investigator try to find her. So now we confront him a second time on the second lawsuit, and he cannot produce his plaintiff. Now Mr. Pinnock sues me number 3. This time, it's a class action statewide suit for the visually impaired. When his plaintiff shows up in court, she was not visually impaired. In fact, she brought a book and was reading it. So we have 3 lawsuits at this point, and it was obvious I did not want to defend a class action litigation, which could have cost a lot of money and a lot of time. So we settled up for a minimal fee of $2,500, and that was a business decision. Do I think this is unfair? You better believe I think it's unfair. It's not unfair to a person that wants proper access to my facility. I'm a merchant. I have customers that have disabilities. I want my stores to be in total compliance. But I don't want an attorney doing drive-by litigation on me. I don't want to get a notice in the mail that I am going to be sued for a ridiculous amount of money for this shotgun number of little grievances that were not true. And I am probably one in one day of maybe 30 of his defendant victims. Yes, that's unfair.
Alfredo Garcia may be one of the most egregious serial litigants in California. He is an illegal immigrant with a vast criminal record, including felony convictions for drugs and illegal weapons, as well as a number of DUI arrests. Yet he has made hundreds of thousands of dollars by filing over 500 ADA lawsuits against California businesses. But he recently found himself in a position that few serial litigants have ever had to face, as a unique set of circumstances brought one of his many cases all the way to a trial by jury.
My name is Jarek Rochelle. A couple of weeks ago, I had the pleasure of going to jury duty. The case revolved around just one witness, really, Alfredo Garcia. I was surprised that out of 500 cases, this is the first time that he's ever gotten to a jury. Probably even more surprised that it was the defense attorney's first time as a lawyer in front of a jury, although he had previously been a Superior Court judge.
This was after I retired. My auto mechanic showed me some papers he'd been served with and asked me what I thought he ought to do about them. Alfredo Garcia said he had used the bathroom there and that one of the 2 grab bars by the toilet was missing and that the mirror was mounted too high, so that's what he sued for.
My understanding, too, is that Alfredo Garcia is just one of quite a few serial plaintiffs represented by the plaintiff's attorney, the offices of Merben and Merben. Obviously, this has been something that he's done successfully, and he's made a lot of money off of it.
Right from the outset, I didn't think he had much of a legitimate claim because I had seen an awful lot of these cases when I was a judge, and I knew exactly what they were about. Very few of these cases are taken to trial. Mine, I knew from the beginning I would take to a jury trial because I didn't charge my client for my work, and that's why it became economically feasible to defend the case all the way.
It only took about 15-20 minutes to deliberate. We found that It wasn't a public restroom. It was an employee restroom that he was allowed to use. He did not encounter an obstacle because he didn't even attempt to try to use it. Then the last thing that we found that what didn't happen was he wasn't harmed by it. It was more believable that this was essentially a job for him. He went out on a regular basis looking for violations and used the law to make money.
One of the most troubling aspects of Alfredo Garcia's barrage of litigation is the fact that California taxpayers are the ones who are footing the bill for his lawsuits. Like most serial litigants, Mr. Garcia requests and is granted a waiver of court filing fees for almost all of his cases.
Every single time that he got to waive filing fees, that was essentially a cost that I took on, that all taxpayers took on. It's $500 each and 500 lawsuits, that's what, 25,000? 25,000? 250,000. $250,000 worth of filing fees. I mean, it boggles the mind.
The fee waivers were based upon obviously a claim of indigency. Garcia gets hundreds of thousands of dollars settling these lawsuits. Anybody making the kind of money these guys are making shouldn't get fee waivers.
The legislature and the courts together decide whether someone is qualified to receive a fee waiver. It's not something that I determine, it's not something that the client determines, it's something that the court determines.
When you apply for a fee waiver application, if you check the box Medi-Cal, that fee waiver application is rubber stamped. Once you get a fee waiver, you then have the ability to waive such costs as process service by the Sheriff's Department. So now the public is footing the bill for the Sheriff's Department, serving these cases.
In my case, Mr. Maribon did use the sheriff to serve process, and so that was done at public expense.
So not only are they clogging up the system's also not getting money that should be paid by these litigants.
For years, legislators in California have been trying to introduce reforms into the law that would alleviate the problem of serial litigation. Unfortunately, these attempts have been met with fierce opposition, since many interpret any proposed ADA reform as an attack on the rights of the disabled. In 2011, Senator Bob Dutton drafted Senate Bill 783, which would require a potential plaintiff to first notify a business owner if there was an ADA infraction found within their establishment, at which point the business owner would have a specified period of time to correct the problem before a lawsuit could be brought.
Madam Chair, this bill, SB 783, seeks to stop abusive ADA lawsuits by giving businesses 120 days to address ADA violations without fear of litigation. I have brought this bill forward as an urgency measure because small businesses throughout my district are being threatened with lawsuits for minor or even non-existent violations.
What my bill did was to try to eliminate the needless cost of going to court. And if you truly have some type of minor infraction that's taken place within the business, why not give the business owner a chance to remedy the problem and fix it instead of going right to court?
When a person goes into a place of business and they are denied equal access, it's already too late. So the notice provision would not help. It would make the place of business come into compliance, sure, but what about compensating the individual who was there and who has already been affected by the problem?
Unfortunately, I do feel that there are some attorneys that actually have gone out of their way to kind of use these types of acts for personal gain. If they were really interested in helping these very same people that they're saying that they want to help, they'd actually encourage and support a bill like what I proposed, because if the business have a chance to repaint their parking stripes or they put the right signage up, I think you'd actually find more compliance.
That legislation's been attempted, or various forms of it, I think at least 5 or 6 times. Attorney lobbies have been involved in lobbying against it, and they've basically never gotten out of committee. They just can't get past committee vote.
Thank you very much, Senator Dutton. I appreciate that you do have people who I think are very well-meaning, who have, serious concerns, and I know your thoughts are in the right place advocating for your local community, but I'm sorry that I will not be able to support you on this matter today.
Thank you.
All right, looks like we're ready to open the roll. Please, Madam Secretary.
Evans, no. Corbett? No. Corbett, no. Leno? Leno, no.
Why do I think they failed in committee? Believe me, I wish I knew. Trial lawyers are a very powerful special interest group here in Sacramento, and I think they're also very powerful back in Washington, D.C.
All you need to do to understand what's going on is follow the money. Look at how much these legislators have received who consistently vote against these reforms. The legislators who are in control, who have the key votes to bring these measures forward, receive so much money from the trial lawyers lobby that they simply do not vote in favor of any reform that's going to limit the number of lawsuits in any meaningful way. I'll be honest with you, I was very troubled by the votes that some of these legislators cast. Over the years, certain senators have made comments to me that made me wonder if they really understood the measures that they were voting on. So I began to wonder if their offices were compliant. I went to each of the legislators' offices. I saw the very same conditions that hundreds of lawsuits have been filed about. Senator Corbett's office in San Leandro, that is her district. One of the things I noticed is that there was a parking area for this group of buildings that her office was in, and there wasn't a single disabled parking space. So I then went to her office in Fremont, and I saw there were a couple of spaces that had been half painted over. There was still a disabled parking sign hanging above the space. Now, it may have been a work in progress, but the fact of the matter is my clients have been sued when they were in progress of making changes, and I thought for the majority leader, the person saying there is no need for reform, you would think that those who would vote against reform would have an exceptional understanding of these issues and that their offices would be exceptionally compliant. In 2 out of 2 locations, I found anything but that. I then went to Senator Noreen Evans' offices and Senator Mark Leno's offices and saw similar problems. For example, in the Napa location, right out in front of the building, I saw signs that said van accessible, but there was no access aisle. And what I think they were using as an access aisle was the curb. My clients couldn't do that. It's potentially a dangerous situation, and the list went on and on. I went through each of the offices that I could access, and I didn't see one that didn't have significant problems. All the same sort of things that my clients are being sued for. And it was heartbreaking to feel like they're so indifferent to the number of lives that are wrecked and businesses that are closed and jobs that are lost because of these lawsuits. They should be ashamed.